morning, ladies and gentlemen, aspiring law students of Taylor's Law School. Today, Taylor's University proudly presents to you our dialogue session on undue influence. We are joined by our panelists of legal experts. First off, Ms. Zafa Farouk.
Good morning, students.
Have a seat. Ms. Raju Sarah. Ms. Yan Chi. And Mr. Omar Abdullah. Last but not least, Mr. Law Yunzhen. My name is Wilson, and I'll be acting as your moderator for today. Thank you all for being here today. Thank you to our 5 panelists for taking their time. Well, first off, let me start off with the question of the day. Our panelist is going to compare and contrast the different aspects of the English position and the Malaysian position regarding undue influence as a vitiating factor in contracts. Now, our English position experts, Ms. Raju Sarah and Ms. Zafa, will now take it to you guys on the development of undue influence over the years.
Thank you, Wilson. So basically in English law, it's okay for you to have influence. It is only when that influence has exceeded the acceptable limit, then only it becomes a problem. I will pass it to Zafa now.
So the courts have identified 2 forms of undue influence, which is actual and presumed undue influence. This was established in the case of Bank of Credit and Commerce International and Abudi. Actual undue influence, in cases of actual undue influence, the plaintiff's mind must have been influenced by the defendant in some form, while in presumed undue influence, there must be already an existing relationship for the plaintiff to be influenced, which means that the plaintiff must be in a position where the defendant must have the defendant must be in a position to have a manifest disadvantage over the plaintiff. So I will pass it to Jasmine to talk about actual undue influence.
Thank you, Zafa. So Richard Stone in Modern Law of Contract talks about actual undue influence, where here the claimant must prove that the defendant used actual influence directly, and there is no need for there to be a previous history of such influence. It can actually be a first-time transaction. This is where Class 1 comes in. So if it's actual undue influence, it's Class 1. Zafa will continue.
So in Class 1 cases, this was established in BCCI and Abudi again, there must be 4 elements, which is the first one is the wrongdoer must be in a capacity to influence the victim. The second is that the influence must be exercised by the plaintiff. The third one is the exercise must be undue. The fourth one is the undue influence brought the transaction. In the case of BCCI and Abudi, the but-for test was overruled. And in Class 1 cases, the burden of proof is on the victim to prove that the undue influence was exerted by the stronger party. Which means that the defendant must be in a position, again, to influence and have a advantage over the plaintiff. And the victim must, in cases of undue influence, must be in a position where they are not able to exercise their free will or free choice, do not have access to a third-party solicitor advice. I will pass it to Jasmine to talk about presumed influence.
So as Zafa said, we're moving on basically. The first step is that the claimant must prove that there was a relationship of trust and confidence between the two parties, and there has been an abuse of that relationship. So this is where the special relationship comes in. Basically, there are two classifications, 2A and 2B, as established in BBCI and Agudi, as mentioned earlier. So 2A is where special relationships comes in. So, for example, if like parent and guardian, religious advisors, medical and patient kind of relationship. 2B basically is where, for presumed undue influence class 2B, you do not need to have a special relationship. You just need to show that there has been a history of trust and relationship before in the past. Moving on to the second element, Safa will continue.
The second element of presumed undue influence is that the transaction must call for an explanation, which is a situation where the actions of a plaintiff cannot be explained by generosity or friendship motives. Presumption will not give rise to a sufficient explanation. And third is rebutting the presumption. In rebutting the presumption, the defense showing the complainant entered into the matter, his or her fully unconstrained, usually with benefit of legal advice. I will pass it to Jasmine to give the last 2 points.
Basically, what Zafa is saying that, as we know, the third stage is rebutting the presumption, where the defendant will try to defend himself. So one of the defense the defendant can use is that the claimant actually received legal advice to show that he did it. The claimant entered into the agreement knowing full well the risk of it. So that is all from us.
Right. Thank you, Ms. Sarah and Ms. Afa. Very interesting, intriguing points on the position of the English law on undue influence. And I'm pretty sure, let's take a 2-minute breather.
For all you aspiring lawyers here to be studying right now in Malaysia, you should know that undue influence in Malaysia is mainly regulated by our very own Contracts Act 1950. Before that, we used the English common law to
substantiate our position. Is that true?
Yes. Thank you, Wilson. Thank you, Mr. Wilson. That's very helpful. What you call? Feeler. He's a very helpful guy. All right. So, as we know, after 1950, we are using our Contracts Act, and Section 16 of our Contracts Act that is how do you say it right now? Section 16 of our contracts. Undue influence in Malaysia is regulated under Section 16 of our Contracts Act, which is in pari materia with the corresponding provision in the Indian Contracts Act 1872. Thus, this makes it compatible with Indian law as well as English law, because our Contracts Act is substantially based on the rules of the English common law.
Right. So sorry to cut you off there. What I'm trying to get is, so you're saying undue influence in the Malaysian context is sort of defined by the English common law, but refined by the Indian Contracts Act.
Exactly.
Right.
Exactly. That's very good of you. That's a very good comparison that you just made. So, Section 16, subsection 1 states that there are 2 elements that needs to be established for there to be undue influence. The first element is a position of dominance, and the second element is the dominance being used to obtain the unfair advantage. So what do I mean by that? Let's take it step by step. The first element is where the relationship that exists between the 2 parties is that one is in a position to dominate the will of the other. So, having said that, this was regarded as essential in the Raghunath Prasad's case, and it was adhered to in cases in Malaysia such as the HSBC Bank versus Syarikat United Leong Enterprise, as well as the Alliance Bank Malaysia and Exelos Corporation case. The second element, where I had said that the dominance used to obtain the unfair advantage, this was emphasized in the aforementioned Pusat Turais case in the Indian Privy Council court. This was followed in Ibrahim bin Musa and Bahari bin Nayan case, and in the English doctrine, as our very good English experts that Raja Sara and Zafar just said, this is called to manifest a disadvantage. So moving on to section 16, subsection 2. Just let me get my bearings a bit. Section 16, subsection 2 regards the types of relationships that this position of dominance and unfair advantage, where this undue influence could arise from. So those relationships mainly are of three categories. One, where there is a real and or apparent authority that is present in that relationship, such as a father and son relationship, which is as shown in the case of Ko Cheng Bok and others, and Ko Cheng Poon and others, where that case, okay. The second category is where there is a fiduciary relationship, where there is a trust and confidence there. This is shown in the Tara Raja Ratnam and Dr. Jaginder Singh and others case. And the thirdly, lastly, where mental incapacity could be established. Now, the section 16.3a, we are looking at, okay, section 16.3, we are looking of the proof of undue influence. So in 3a, it deals with the proof of undue influence when two elements are established. Firstly, the position is in the dominant, the person is in the dominant position, and secondly, when the transaction appears on the face to be evidently unconscionable. More on that later. So when these two elements are established, the burden of proof of that contract, that it was not induced by undue influence, will lie on the person that is in the position to dominate the will of another. So once we are able to establish undue influence, sections 10 till 13 talks of free consent and how free consent is vital for a legitimate contract, a legal contract, enforceable contract. And as you all know, a contract that is unenforceable is not a real contract. And once that is present, the option for you to rescind due to it being a voidable contract is governed under Section 20 of the Contracts Act 1950, where it says that it is voidable at the behest of the innocent party That's it. Now, when we talk of relief, there is a few differences and similarities mainly, but I'll leave it to my esteemed colleague Yanchi, that is an expert on the contrasts of it, of Malaysian position and the English position on undue influence. So, speaking of section 16 subsections 3, there is a contention right now where in 2006 Justice Gopal Siriram had introduced unconscionability for the first time into our doctrine, our legal doctrine. And there are arguments that it could be developed in our section 16 instead of adopting or making a new doctrine from scratch following some other, I think it was Canadian law. So my esteemed colleague Omar will be handling that.
Thank you, Daniel. You might be surprised to know that the doctrine of unconscionability is very similar to the doctrine of undue influence. That is because they both share similar rules of equity along with the prevention of fraud. As time went by, the doctrine of unconscionability provided relief for exceptional cases, which included the plaintiff being affected by factors such as inexperience, youth, sickness, illiteracy, lack of education, or isolation. These factors are also known as the poor and ignorant principle. A case which involved the poor and ignorant principle would be the English case of Cresswell and Potter, whereas in this case, Mrs. Cresswell was a telephonist for the post office. She had divorced from Mr. Potter and then had contracted to convey him her interest in return for a release from the mortgage liability. 2 years later, Mr. Potter sold the property for £350,000, making a £1,400 profit. As a result of that, Mrs. Cresswell successfully argued that she is entitled to get half of the profit due to the fact that she had exploited her weakness to the extent that it had vitiated her consent to the contract. The court later held that since she was vulnerable to this was equivalent to the poor and ignorant person. However, although there were some specific exceptions as to when a plaintiff can bargain unconscionability, Brown-Wilkinson J stated that the need for some more reprehensibility can be found in the case of Alec Bob and Total Oil Great Britain. Whereas in this case, Peter Millett identified 3 main necessary elements before a plaintiff can bargain for unconscionability. These elements are that firstly, one party must be in a serious advantage to the other party. Secondly, that one weakness must be exploited by the dominant party. And thirdly is that the resulting transaction must be overreaching and oppressive. However, in Malaysia, the doctrine of unconscionability is applied very similarly. This can be seen in one of the first principal Malaysian key cases which involve the doctrine of unconscionability, which is the Malaysian case of Foy Bian Credit and Ising and Kim Bian Timber. Whereas in this case, Chong Siu Fai referred to the English case of multi-service where he stated that, and I quote, in order that a party may free himself from complying with an agreement he had entered into, he must show that the bargain or some of its terms were unfair and unconscionable. It is not enough to show that in the eyes of the court it was unreasonable. A bargain cannot be unfair and unconscionable unless it is shown that one of the parties had imposed an objectionable term in a more reprehensible manner. After the judgment in Foy Bian's case, the case later on became one of the principal cases involving the doctrine of unconscionability in Malaysia. As mentioned previously by my colleague Daniel, the doctrine of unconscionability can be seen in another Malaysian case, which is the case of Saad Murray and Chan Wan Swa and Anor. Should I mention everything? Oh, please. No, because it's a lot.
Say, open the door to the doctrine of unconscionability. It's a landmark case. Okay, so what case did you just say that had unconscionability at first?
Foy Bian Credit. No, at the first case is an English case.
Oh, those are the
Yeah, it's an English version. Can I switch things to Foy Bian Credit? This
Oh,
it's gonna turn out bro.
still
Yeah.
So you just say that you open the door. If you open the
You don't need to say like it's like Canada. You can say it's flexible. And then you talk about the 1638, section 1638. So how it can be developed now.
Now, the case of Sam Morley is actually a landmark case because it actually opened the doors to the doctrine of unconscionability, along with its decision that has been considered in two subsequent cases. Some reservations have been raised against it in one of the chief concerns in the introduction of the doctrine of unconscionability in the light of Section 16 of the Contracts Act 1950. Section 16, subsection 3, had raised the question of whether the doctrine of unconscionability is separate from the doctrine of undue influence or not, and whether unconscionability can arise in sections relying on the Indian case of Abdul Majid and Kirod Chandrapan, that where good security had, in this case, good security had been furnished and the interest loan exceeded 18%. A presumption was raised that the contract was unconscionable and is liable to set aside, and that was liable to set aside. In order to conclude, Section 16, subsection 3, paragraph A, has been used in order to identify that the doctrine of unconscionability is actually separate from the doctrine of undue influence.
Right. Thank you, Omar. Thank you, Mr. Omar, and also Dan, for such insights yet again on the Malaysian position of undue influence. But there is something that, because of these differences in the positions, it has created a lot of, I believe when we were law students many years ago, we had many doubts as well as to how different the two positions can be. So I guess right now, Ms. Yanchi and me would have a short conversation short conversation on how the differences of the two positions as well as how similar they are. So, Ms. Yanchi, would you like to start on how different the positions is?
Yeah, thank you, Mr. Wilson. Consider there are differences between English and Malaysia position. We would like to share about it. The first differences is the definition between English and Malaysian law. There is no precise meaning of undue influence in English law. While Malaysia position, Section 16 subsection 1 states that a contract is said to be induced by undue influence where the relations sub-16 between the parties are such that one party is in a position to dominate the will and the other and uses that position to obtain an unfair advantage over the other. Secondly, the differences can be found under actual undue influence and presumed undue influence. Although it is not really clear that whether the distinction between actual and presumed undue influence found in English law, there is no need to prove any previous history of such influence. Hence, manifest disadvantage no need to show in English law, as it can be seen clearly from the case of CIBC Mortgage and P. The court held that CIBC is entitled to enforce the change and there is no agency and actual or constructive notice and no need to show manifest disadvantage in cases of actual undue influence. There is no need for the party under actual undue influence who has been unduly influenced to show that the transaction was manifestly disadvantageous to set it aside. By the Malaysian law, the party under entire cases that has been unduly influenced must show that the influencer obtained an unfair advantage. For example, there is an old lady induced by her solicitor under strong pressure to sell her a large and inconvenient family home at full market price. Manifest disadvantage might be very difficult to demonstrate in such a case, but as a matter of principle, should she be left without any remedy? Besides that, manifest disadvantage has been rejected and something else relationship showing victim repose trust and confidence in the dominant party. In the case of special relationship, influence is presumed. In other cases, victim must show that he or she did actually repose trust and confidence in the other in the past, and upon such proof, influence is presumed. Secondly, there is something about the transaction that calls for an explanation, which is the reformation of the manifest disadvantage. Thirdly, the dominant party must then give a sufficient explanation to rebut the presumption of undue influence. The more disadvantageous the transaction, the more cogent must be the explanation. And the reason that we need something which calls for an explanation is probably disadvantageous wasn't a necessary requirement, but it is still relevant. Lord Winkle also pointed out that the exercise of undue influence is unlikely to occur where the transaction is innocent. And Wilson, can you explain the differences between the third party in English law and Malaysian law?
Well, certainly, but before that, I think we can all agree on that the case of RBS, Royal Bank of Scotland, and Attridge can really be decided differently under the Malaysian position. Do you all agree on that?
I think that's
Pretty much, right? Well, previously, Ms. Yanchis asked me to explain on third-party undue influence. Well, to put it simply, if and when an undue influence is exerted by a third party, the contract is voidable, but only if the third party is an agent of the party seeking to enforce the contract. Well, the agent or the party seeking to enforce the contract must have had knowledge or constructive notice of the undue influence exerted by the third party. Under presumed undue influence, a contract may be avoided where the undue influence is exerted on one party to the contract, exerted on one party to the contract by the third party if the third party was acting as the other party's agent, and if the third party has actual knowledge on the undue influence. Well, the position is the same with actual undue influence, but on the other hand, Daniel previously mentioned section 16 subsection 2, right?
Yes.
Well, this applies to all the varieties of relations, fiduciary or non-fiduciary, of real or apparent authority in which the dominion may be exercised by one person over another. Not just, once again, mentioning not just only fiduciary relationships. Well, I guess with differences, there are similarities as well. Similarities between English and Malaysian positions on undue influence are, firstly, the transaction that there must be a transaction that calls for an explanation. This was first introduced in Royal Bank of Scotland and Attridge, as mentioned before by Ms. Zafa and Ms. Arcera. And secondly, if the undue influence is proven, then the contract can be void and rescission can happen. Well, pardon me for a second. I have forgotten to mention that in the differences that I mentioned previously, Section 76 of our Malaysian Contracts Act actually says that the right of rescission comes with entitlement of compensation, while in English common law, it is either the whole transaction will be set aside and the issues of restoring the parties to their original position, as best as the law can do if the circumstances will arise. This is what's stated in our Section 76 of Malaysian Contracts Act. Now, back to similarities. Thirdly, if there is a presumption of undue influence, the burden of proof shifts to the influencer to show that the contract was was not induced by undue influence. Ms. Yanchi, do you want to continue on the similarities? Or
Okay, just continue.
oh, okay, fine. I guess I'll finish off the session. And both English and Malaysian law do not recognize husband and wife as a special relationship. Once again proven by the case of RPS and Attridge. I guess this sums up our segment on undue influence. We thank our panelists for their time today, and till the next dialogue, study hard, everybody. Thank you.